Hey, welcome everyone to Lecture 6 for International Regulatory Frameworks for Climate Change and Environmental Management. So I think this is a really exciting lecture. I get worked up about it. It's UNCLOS, the United Nations Convention on Law of the Sea, 1982. Really, did I say really? Important convention. So in this lecture, we'll deal with UNCLOS. In maritime jurisdictions is particularly important. Mentioned land source marine pollution, deep sea mining and fisheries, but it's mainly maritime jurisdictions is what you really need to understand, because it's, you can see, on a map, you know where land areas are, but you also need to understand where countries control in their surrounding waters. And so maritime jurisdictions is a critical component of the overall regulatory system. Also want to deal with, at the end of the lecture, an example of an agreed high seas fishery regimes. So what we'll find is UNCLOS is really good at regulating fishing within national waters. So out to 200 nautical miles, UNCLOS is great. Outside of that area, it's up to, it's really poor. And so there's a whole range of other conventions that deal with fisheries that are on what are called the high seas, so outside of national maritime areas. And just look at two, but particularly the first one, the Convention on the Conservation of Southern Bluefin Tuna, 1994. So just as an example. So fisheries regimes, cool. Okay, context. So we're moving now into the 1980s to 1990 period. So it's a period of ongoing growth and expansion in many parts of the world. Government and public concern for the environment are heightened by emerging global threats such as the scientific discovery of the hole in the ozone layer and the Chernobyl nuclear disaster in 1986. So ozone we'll deal with in the next lecture. Chernobyl, I'm sure everyone's vaguely familiar with it, but 1986, there was a catastrophic nuclear accident occurred due to human error at the Chernobyl nuclear power station in the USSR, now part of the Ukraine. It sent a radioactive cloud across Europe, and Russia or USSR didn't actually tell the neighbouring countries that it happened. And I think it was first picked up in Sweden, where they detected high levels of radiation, and they thought there had been a leak from one of their own plants. And then they checked and there wasn't, and finally they worked out there was something else was coming from elsewhere. And it was a situation where I think that they were doing a test on the shutdown of the reactor, and it just catastrophically went really bad. And it was a huge deal in Europe at the time. The threat of pollution from that. So that's the context, the historical context. Emerging heightened concern, alarm for hole in the ozone layer, threats like nuclear disaster from Chernobyl. In that context, there's a seminal report, the Brundtland Report, in 1987, which established the concept of sustainable development as a key international principle. And it's also a period of major geopolitical shift as the Soviet Union disintegrated and the Berlin Wall fell. Okay, so that's the political context. This is 1982, was the UNCLOS was signed. It had actually been worked on for a decade leading up to that. I love this quote from Gillian Triggs. Mentioned her before. Fabulous Australian international lawyer, has been fighting with the federal government. She's been the Australian Human Rights Commissioner for the last 5 years or so, and has been fighting with the federal government over their inhumane treatment of people on Manus Island and a range of other issues. Anyway, amazing woman. She wrote in her book, International Law, 2006, I love this quote: "The international law of the sea ebbs and flows with the evolving geopolitical priorities of the age." Just a lovely, evocative, ebbing and flowing, great for law of the sea. Great metaphor. UNCLOS, in terms of basics of it, it's a massive convention. It's meant to be, the comprehensive treaty that dealt with the law of the sea, and it established a lot. It hasn't dealt well with fishing on the high seas, but it does a huge amount of other things. So first conference to negotiate it was held in 1973. Eventually it was signed in 1982, so 9 years of negotiations. It came into force in 1994, so 12 years to come into force. And so that's interesting. Remember our normal process for the normal treaty process, from negotiation through signature, through ratification, through entry into force. 20 years from when it started to actually when it entered into force. 167 parties, not including the United States of America. So the US was one of the driving forces behind it, but the US, because of its constitutional arrangements and the need to get a 2/3 majority vote from the US Senate, for the last decades, the US Senate has been hostage to the small states, because in their Senate they get, the Senate has 2 senators from each state, so some of the really small Midwest states where there might only be a few million people have 2 senators, and a state like California, which has I think over 20 million people, has 2 senators. So the big populous states, which tend to be more progressive, are outnumbered effectively by all these small states with senators from, so the right wing of the American politics is basically structurally built into their Senate, and it's going to be impossible for them to unpick it. And it's meant that their Senate is very, very anti-international, anything that isn't to do with, armament or terrorism or something like that. If it's a terrorism agreement, to deal with, agreement to combat terrorism, sure, that would sail through. But if it's something that's got the words United Nations in it, because that's one of the problems with this convention, it's the United Nations Convention on the Law of the Sea, not just the Law of the Sea. The UN is right there in the title, and a lot of the US senators really despise the UN. So it's basically never been ratified by the US, even though every government since it was signed has basically begged the Senate to allow them to ratify it. They haven't been able to do it. Okay, the Secretariat's in New York, in the UN in New York. The meetings of the state parties occur annually. There's a homepage. You could just search for UNCLOS, you'd get that. Okay, in terms of structure, it's massive. 320 articles divided into 27 parts plus 9 annexes. The parts most important to environmental management, particularly that I'll focus on, are parts 2, 5, 6, 7, 11 and 12. So the territorial sea, exclusive economic zone, the continental shelf, the high seas, the seabed and ocean floor, which is very confusingly called the area. Why couldn't they have just called it, the ocean floor or something? Called it the area. It's really confusing. And then part 12, protection and preservation of the marine environment. So the historical background to the maritime zones in UNCLOS is really important to understand. It's Gillian Trigg's comment about the law of the sea ebbs and flows with the evolving geopolitical context of the times. Really is just so apt. So I just want to start by looking at historically what were the maritime zones. So customary international law on international maritime jurisdiction, and there was a really important decision called the Bering Sea Fur Seals Arbitration in 1893, which basically held that countries could control out to 3 nautical miles. So the Bering Strait is between Russia and Alaska, and the dispute concerned fur seals which are on the Pribilof Islands, which are circled in red there. So the Bering Strait was named after I think it was a Danish explorer that the Russian Tsar engaged to sail up and explore in a time when he took up 3 vessels. I think he came back with 1. They had no motors, extremely dangerous. Sailed through the strait and yeah, he actually did two expeditions up there from memory. So this is a picture of his second expedition. It was wrecked in the Aleutian Islands in 1741. Bering died on Bering Island on his second voyage, probably from scurvy. And yeah, the Bering Sea and the Bering Strait were named by Captain James Cook on his third and final voyage in 1776 to 1779, where Cook then, I think his vessel was damaged, basically trying to explore. They were trying to look for the Northwest Passage. And his vessel was damaged, and he went back to one of the islands where he was killed by the inhabitants of the island. Anyway, pretty bloody scary to be going there. No motor, no map, don't know where you're going. Huge storms, huge seas, lots of rocks. Just as an interesting historical aside, this is a copy of the check that the US used to purchase Alaska from Russia in 1867. So, if you know the history, Alaska was originally Russian territory, and then yeah, in the 1860s, the Russian Tsar was basically needing money, and they thought that they had taken everything of value out of Alaska, furs and that sort of stuff, and so they sold it to the US. And at the time, the Secretary of State was severely criticised. His name was William Seward. He bought it, well, he was Secretary of State, and was bought for $7.2 million. And there was ridicule in the US. Alaska was called a sucked orange, saying Russia had already drained all the value out of it. It was called Seward's Folly and Seward's Icebox. Anyway, there's this interesting article back in 2012, and the solution to US debt: sell Alaska. You could raise at least 2.5 trillion, which wouldn't completely write off US debt, but would go a long way to it. Anyway, interesting. I think an interesting aside in terms of it's also in terms of how countries acquire sovereignty over an area. It used to be you could invade, up until basically the UN Charter, you could invade a territory and take it by force, and conquest was one way you could acquire territory. You could also acquire it if there was no one there. It was terra nullius. So Antarctica, for instance, there was no one living there. It's a landmass. You would think that you could acquire it by just discovering it and then occupying it, so effective occupation. You can also acquire territory by buying it, so it's sold. Alaska was, the US acquired sovereignty by purchasing it. The Pribilof Islands are part of a chain of islands, down from the Bering Strait. Here's just some images of them. You've got some fur seals actually there in the distance. And a lot of the architecture looks quite Russian. It's got, a lot of the communities there got a lot of Russian heritage. Here's a fur seal rookery. Here's a couple of images, illustrations back from when fur seals were being heavily exploited. So here's looking out over one of those islands. And here's some images of a seal meat frame. So they killed the seals for meat, but also for their furs. You can see a man standing on a boat there going out hunting for them. And then here's the killing gangs at work. So they would actually just walk out in gangs and club them to death, take their meat, take their skins. So, and here's the catching fur seal skins. So turning them, I think, into fur coats is what they do there. Catching, I think, is where you dry skins, I think. Okay, so here's the island, often called the Fur Seals Islands, the Pribilof Islands, acquired by the US in 1867, Bering Sea. So essentially what happened was basically they were being wiped out, these fur seals, and in the 1880s, 1890s, the US tried to control the take of these fur seals so that they weren't completely wiped out. The problem was that the fur seals were badly behaved. They wouldn't stay in their rookeries where the US could protect them. They wanted to swim out. Could you believe that? Swim out away from the islands. And when they swam out from shore, they were taken by vessels that were flagged in Canada or Japan. What was the other one? I think Russia as well. So basically foreign flag vessels would come and take them. And the US basically sought arbitration with the United Kingdom, which was where the Canadian vessels were coming from. And they agreed on arbitration, and it went to an arbitration panel, so eminent international law of the sea experts at the time, who were seen as impartial by both parties. And they delivered the judgment in the Bering Fur Seals arbitration, which basically formed the cornerstone for modern marine protected area management. So basically they found that the US could only control the fur seals when they were on the islands or within 3 nautical miles. So that was the limit of maritime zones. Do you know why 3 nautical miles was the limit at that time? Do you know? Quite famous for why the traditional maritime zones were 3 nautical miles. Because in the, I think it was the 17 or 1800s, 3 nautical miles was about as far as cannons could fire. And so it was the limit of what you could control from the land. You could fire a cannon at the time when 3 nautical miles became established. And the emphasis at the time by the big maritime nations, so the United Kingdom, France and Spain, was they wanted trade, and they were very powerful in terms of their navies, and they wanted the minimum maritime zones because they didn't want countries to be able to control their shipping. So the emphasis was on a small maritime zone. So that's where 3 nautical miles originally comes from. Okay, so the conservation, so the tribunal said 3 nautical miles is the limit, but it also said, well, something needs to be done. So they came up with a conservation plan for what to do about it. So the first thing they recommended was a prohibited zone where you couldn't kill them. Second was a closed season in a defined area of the high seas with exceptions for indigenous hunting. So 3, a limitation on the type of vessel used. 4, a licensing system for seal hunting. 5, use of a special flag while sealing. 6, keeping of catch records. 7, exchange of data collected. 8, government responsibility for choice of suitable crews. 9, a plan enacted into national uniform laws in the US and Britain and national measures adopted to ensure enforcement. And 10, a 3-year ban or moratorium on all sealing. So if you look at those, that could read like a modern prescription for a marine protected area. All of those things you could easily see in any marine protected area anywhere around the world, all of those elements. This was groundbreaking at the time, 1893. That's what they recommended. Unfortunately, it also follows the course of a lot of marine protected measures. It was ineffective in conserving the fur seals. US and British Canadian vessels re-registered in Japan and other countries to avoid being subject to US and Canadian laws, so went to flags of convenience. The seal population continued to decline until international agreement between all nations involving sealing was signed in 1911. So, flags of convenience, really common course for fisheries. Any country that tries to regulate it and regulate their vessels, the fishing vessels just go to a jurisdiction that doesn't care. In that context, this is the growth of the major milestones of expansion of international maritime jurisdictions. So 1893, 3 nautical miles. 1972 was 12 nautical miles. And then 1982, UNCLOS, 200 nautical miles. Yeah, being the major one. UNCLOS, as we'll see, has other limits, but 200 nautical miles is a general one for fishing. So that brings us to the modern framework for maritime zones under UNCLOS. So this is parts 2 to 7 of UNCLOS. So I didn't print this out. I put this up. I'll print this out. But it's available on the Blackboard site, and it's essentially this really good diagram of summarising the major maritime zones. So you see there you've got a baseline, which is essentially the low water mark, and then you go out to 12 nautical miles as the territorial sea, and then exclusive economic zone is actually 200 nautical miles out from the baseline. It's not 212 nautical miles. The contiguous zone out to 24 nautical miles is more about customs, and then the high seas beyond that. And you see there the area as well. So there's the continental shelf down at the bottom. So that's based on the seafloor, and then beyond the continental shelf is what's called the area. As I say, I wish it had just been called the ocean floor or something that was more descriptive than the area. Yeah, the continental shelf has a maximum limit out to 350 nautical miles. Okay, so looking at that in practice, if you look at Australia, that's our maritime zones. So you see the areas in mustard are the 200 nautical mile exclusive economic zone, and then you see bits like off Western Australia where there's that light blue. So that is the continental shelf extending beyond 200 nautical miles, and similarly off Tasmania, the continental shelf extending beyond 200 nautical miles. So basically what we'll see is Australia can control fishing within its EEZ. It can also control petroleum and mining on its continental shelf outside of the EEZ. It can also control petroleum and mining within its EEZ, but you see how the continental shelf in practice can extend beyond 200 nautical miles. Yeah, and its limit is 350 nautical miles.
So why is not continuous after the exclusive economic zone? Why I can see
so which bit, like here?
Why is not a continuous surrounding?
Because physically the continental shelf doesn't continue, so it's a physical, so if we looked at a map of the seafloor,
for the bathymetry.
Yeah, the continental shelf doesn't necessarily extend. It might only go out 50 nautical miles.
Okay.
So your continental shelf, so all these areas where you don't see a continental shelf beyond 200 nautical miles, the continental shelf falls away before it. So it's a sort of, continental shelf depends upon it physically being there. Okay, cool, great question. And I'm going to focus on some of these bits up here where it's less than 200 nautical miles. So like if we focus in on the east coast of Australia, we've got around Lord Howe Island, you can see those islands where Lord Howe Island is here. So yeah, and then there's continental shelf in that blue. And then you can see there's the dividing line because New Zealand, it's essentially you generally draw a line between two countries. So if you've got less, if they're closer than 400 nautical miles apart, then you split it down the middle. So yeah, maritime zones. So you've got, see there, the yellow being the territorial sea baseline, which is the low water mark. Then out to the territorial sea, the contiguous zone, the EEZ, and the continental shelf. But the big one for us is the EEZ, because within that, countries can control fishing. So here's another diagram just showing those around, you know, a hypothetical coastline. So if we just look over here, see the yellow, so there's rules about how you draw the baseline. It's basically what's shown as the low water mark on large scale nautical maps. And it's not, you know, that exact. And there's rules for where, like on a bay, for instance here, you can just draw a baseline across. And then when you've got to go around a headland or something, or when you can just draw, like there's islands that are in close, you can just draw the baseline around it. So that's all set out in UNCLOS. but we don't have to worry about that because you can basically just use a maritime map produced by the government, and all the difficult work like working out those sorts of things has all been done. It's just shown on maps. But then you've got, as I say, the territorial sea, the contiguous zone, and those are mainly, particularly the contiguous zone, is to deal with customs. So when a ship can be intercepted by, for instance, and check for drugs, if it comes within 24 nautical miles, customs can go on board and check it. There's out in the EEZ, if they're fishing, you can control it, but there's rights of free passage, so you mightn't be able to necessarily just board a ship within the EEZ, check in for drugs or something like that. So we don't have to worry about anything really other than the EEZ and the continental shelf. Now, let's just have a practical example. So Brisbane. This is just from a large-scale map, and I've just zoomed in. And you can see here with Brisbane or Fraser Island, you can see the baseline skipping out around Fraser Island, and similarly around Brisbane goes out around Moreton Island and North Stradbroke Island. So if we look at Brisbane, like that's how the baseline goes out around those islands, and everywhere inside is coastal waters. And can I just mention a point? I'm going to go on and talk about the EEZ. I just want to think about sovereignty versus sovereign rights. So think about it this way, because it's difficult enough to understand what sovereignty is. It's the ability to make laws with respect to an area. Sovereign rights is similar, but not based. It's effectively like the difference between ownership and renting. So, okay, does anyone own their own house or living in a house with, like your parents that own it? So, I own my own house. Okay, who's renting? Or, okay, so we've got some people who are renting. Okay, so when you own it, you can, if you want to put up a nail or paint it or, change something, you can do it. When you're renting, someone else owns it. You've got an agreement with them, so you can live there, and you can even exclude them, so they just can't barge in and say, I want to, stay for dinner. You can say, no, get stuffed. It's, it's our unit, and get out. So you've got rights to use, but someone else owns it. So sovereignty and sovereign rights is something similar in that, except with sovereign rights, there's no one else really owns it, but it's sort of like you don't really own it, but you've got rights in relation to it. So in that context, when we look at something like the territorial sea and contiguous zone, it says the sovereignty of a coastal state extends beyond its land, territory and internal waters, and in the case of an archipelagic state, so something like Indonesia, made up of many islands, an archipelago. Its archipelagic waters and adjacent belt of sea described as a territorial sea. So that's sovereignty. It's basically like ownership. So the breadth of the territorial sea will be 12 nautical miles from the baseline. And then there's, as I said, there's a description in UNCLOS about how you create a baseline. Normal baseline, it's the low water line, as marked on large-scale chart, officially recognised by the coastal state. There's something about reefs and straight baselines as well, when you can basically draw it straight across the bay. Okay, then the EEZ in Article 55. So the EEZ is an area beyond and adjacent to the territorial sea, under which the rights and jurisdiction of the coastal state and the rights and freedoms of other states are governed by relevant provisions of this convention. So Article 56, in the EEZ, the coastal state has sovereign rights. So see, it's that change in terms. It's no longer referring to sovereignty. It's referring to sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superadjacent, so above the seabed, and of the seabed and its subsoil, and with regard to other activities for the economic exploration of the zone, such as the production of energy from water, currents and winds. So if you want to have a wind farm, for instance, in coastal, in an EEZ, then the state can control it. But notice sovereign rights, not full sovereignty. The breadth of the EEZ shall not extend 200 nautical miles from the baseline. So yeah, it's not 212, it's from the baseline. And also did I mention, I'm not sure if I did, I keep using the term nautical mile. Does anyone know how big a nautical mile is?
1 kilometer and 800 meters.
Fantastic. I bet no one else knew that. I bet no one else knew that I think it's 1,851 meters or something, basic 52 meters or something like that. Do you know where it comes from? So, you know, everyone knows, so we use kilometers in Australia, 1,000 meters. In the US, they're still using miles, so 1,600 meters. A nautical mile, 1,852 whatever meters. Where does that come from?
Like taking into account the curvature of the Earth,
Close.
something like that.
Close.
Yeah.
It's equivalent, I think, to 1 degree of longitude or latitude.
Yeah.
It used to be when ships used to, use sextants and those sorts of things, they worked out their position based on latitude and longitude, and it was 1 degree of at the equator, 1 degree of latitude, and it was the distance between them, and that became the standard for measuring distance in nautical terms, and that's where we've gotten. So the original 3 nautical miles came from that. That's the history of it. So 200 nautical miles is actually about 360 kilometres. It's more than just 200. Okay, so Article 76. The continental shelf comprises the seabed and subsoil of the submarine areas that extend beyond its territorial sea through the natural prolongation of its land territory to the outer edge of the continental margin, or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin does not exceed that distance. So it can go beyond it. And Article 77, rights of continental shelf over rights of a coastal state over the continental shelf. Coastal state exercises over the continental shelf sovereign rights for the purpose of exploring and exploiting its natural resources. But basically only the bottom. So you can control basically mining, but you can't control the waters above it. So Article 78, the waters above it, the super adjacent waters and airspace. Does that make sense?
So who has the sovereignty for, like, for example, EEZ, like, to justify if the sovereign right is, like, used rightfully?
So no one has sovereignty as such. So UNCLOS, no one has sovereignty over the EEZ, but coastal states have sovereign rights, and there's just this. It's a confusing distinction. I'm just pointing it out because the language of the conventions actually uses it, and so I just wanted to explain it in that I think it's easiest to think of it like ownership and renting, but that analogy breaks down because there's no one actually owns the coastal waters as such. But under this international convention, there are rights of a coastal state to control activities within that area. So because of their physical proximity to that area. Cool? And no one actually owns that area as such, and beyond it no one owns it as well, but within that area states have rights to control activities within it.
Some activities.
Well, within the EEZ, pretty well everything. You can control fishing, mining, petroleum. Outside on the continental shelf, you can't control fishing, at least in the water above the continental shelf, but you can control if someone wants to, admittedly that those areas are very hard to mine or, because they're so deep. If you're off the continental shelf, you're going to be, by definition, you're going to be in a really deep area, difficult. But under UNCLOS, countries at least have the ability to control it. Okay, so drilling on the continental shelf. The coastal states shall have the exclusive right to authorise and regulate drilling on the continental shelf for all purposes. So what happens if the EEZ and neighbouring countries are within 400 nautical miles of each other? And a good example of that is the Torres Strait between Australia and PNG. So much, much less than 400 nautical miles. I've shown in that little bar there. You know, they're well within that. So basically you split the difference, but you might not even get to an EEZ because there's so many islands there. You can see how at the top of Cape York, the baseline has been drawn out around those islands. And so you don't even really get past the territorial sea before...
It's only about 6 k's, isn't it?
Sorry?
Isn't it only about 6 k's? From Boigu to...
Yeah, they're very close. They're very close. But essentially there's no EEZ in that area because you're still within areas that are... And that little... See the little polygon, the yellow thing? That's a specific treaty between the Torres Strait Treaty. So that's a protected zone established by the Torres Strait Treaty between Australia and PNG for the purpose of protecting the traditional way of life, including traditional fishing and freedom of movement of Australians who are Torres Strait Islanders and PNG people who live in the coastal area of PNG. So there's a treaty about that area within, protected within that. So that's an example. Let's look at a couple of others. So it's just another diagram of it. How is the maritime boundary determined when adjacent countries have winding coastlines? So Article 15, delimitation of a territorial sea between states with opposite or adjacent coasts. Where the coasts of two states are opposite or adjacent to each other, neither of the states is entitled, failing agreement between them to the contrary, to extend its territorial sea beyond the median line, every point of which is equidistant from the nearest points on the baselines from which the breadth of the territorial sea of each of the two states is measured. So basically split it down the middle. Okay, well that becomes hard in practice. UNCLOS provides for settlements of disputes. You can go to the ICJ, and the ICJ has been making a number of rulings. It's one of the biggest areas of its practice is settling maritime disputes. So I mentioned this in the context of whaling yesterday. So big court in The Hague, beautiful building, has a massive bench of judges, so 13 judges, some barristers appearing before it in 2006. So one of the cases it considered recently was a dispute involving the Black Sea between, so the Black Sea catchment, you've got, it was the Ukraine and Romania, I think. Yeah, so this was the, this is from the ICJ's judgment, and the red line, so Romania is, so Romania is here, and Ukraine is here, and their border must be somewhere about there, the boundary. So see the red line and the blue line. So what does the red line give Romania? It's its claim. Why has Romania chosen the red line? Why didn't it choose the blue line?
Because of the economic exclusive.
Yeah, what does Romania get if the red line is the right boundary? Does it get more or less? More. And similarly, what does the Ukraine get if the blue line is the right boundary? It gets more. So they're the two competing claims, and this is what the ICJ decided. So I'll just click between them. So there's your two claims. That's what they decided. Not quite splitting it down the middle, but Romania's claim, particularly out around 4 and 5, is what the ICJ went with. Similarly, there's been a dispute between Nicaragua and Colombia, very controversial. This one was more complicated, took 11 years before the ICJ. It was complicated because there were a range of historic treaties based around, I think, Dutch exploration of the area and treaties between probably Dutch explorers and Portuguese explorers, I think, were particularly, and probably Spanish explorers. So there was a range of treaties, and this is Nicaragua's claim. So Nicaragua is claiming, so here's Nicaragua, and here's Colombia, and this is the area that Nicaragua was claiming, and then here is the area that Colombia was saying that Nicaragua was entitled to. So pretty obvious why Nicaragua wants that and Colombia wants that, because on either one, you know, the differences are they get more. Here's what the ICJ decided, basically went with Nicaragua, based on the complicated treaties around those islands. And there was, yeah, it basically led to, it was hugely controversial, particularly in Colombia. They said they refused to accept the judgment and blah, blah, blah. Okay, so here's just a different one, 2014, Peru and Chile. South America, so you've got Peru here and Chile here. And again, Chile's claiming the blue line and Peru is claiming the red line. And again, the same reason. The red line gives Peru more, the blue line gives Chile more. The ICJ went with this, which, when you look at it, is pretty well split in the middle. But it's obviously not as simple as the ICJ just looking at the two claims and splitting it down the middle, saying, well, that's what you claim, that's what you claim, you can cut it down the middle. The background would be that both parties went for more than they thought they could get. They tried to maximize, like, you know, it's like a common negotiation tactic. If you go immediately to the middle, people think, well, that's your upper end, so they try and drag you further. So, you know, you might, if you're bidding for a house, you might offer them less than you are ultimately prepared to pay, but you're testing to see if they will give it to you for less. Similarly, if you're selling the house, you ask for more and you're prepared to go lower, so you start with two ends and you gradually come together through negotiation. But what you find in common experience is if you start, like you just think, let's just get past all that crap and go straight to the middle, a lot of people think, well, that's your upper end and that's the beginning of your negotiations, and they try and drag you down from there. So you basically need to think, well, okay, if that's the way they're going to play it, let's start and come together. So it's a logical sort of gaming choice to, you know, go beyond what they ultimately think they might get and argue for something more. So that's some examples of splitting, okay? And it's actually quite complicated when you actually look at a real coastline, finding the middle of it. The next slide is interesting because the ICJ in this one also showed how they constructed the equidistant points. So you can see there, when you actually look at that, it makes perfect sense, you know? It does look like it's down the middle of the way that coastline is wrapping around. And now, not all disputes are settled peacefully, so look at a couple of examples. Some countries refuse to accept the jurisdiction of the ICJ, or the International Tribunal for the Law of the Sea is another tribunal that can resolve disputes. So let's just have a look at a couple of them. So I mentioned in the first lecture the Senkaku Islands, which is this dispute between Japan, Taiwan and China, but mainly it's between Japan and China. But all three of those, I'm going to call them countries. Taiwan obviously isn't a recognised country, but it looks like a country, it quacks like a country for all purposes other than the United Nations. It is a country, and it claims those islands. So the three countries claim those islands. They're basically rocky outcrops. They meet the definition of islands, but the history of them, I think I said in lecture 1, they were Japan, when it was a great military power, when it came out of its isolation, it had a great military, great navy, and it basically took the islands by force in 1890 and held them until 1945 when it lost World War II. But in the treaty, the peace agreement with the United States of America, the Senkaku Islands were recognised as Japanese. China has never recognised that and still claims the islands as their own. My view is that Japan did acquire sovereignty of them in 1890 because in 1890 conquest was a way you could acquire sovereignty, and up until 1945 in the UN Charter it was a legitimate way to acquire sovereignty. So they had sovereignty in 1945, and since that time they've continued to exercise it and they've never given it up. So as a lawyer I would say Japan has the better claim. It's not as simple as that though for China. It's a whole range of domestic politics as well as the so as I said in first lecture, there's obviously China and Japan have a lot of history with military fights and the like, and a lot of racial tensions between them. You see like demonstrations in China against Japanese in relation to these islands, and similarly in Japan you see in the news demonstrations against Chinese actions in relation to these islands. So both countries are really fired up about these islands. It's not the islands themselves. What they want is the maritime zones, the oil and gas potentially, and the fisheries around them. So yeah, the second Senkaku Islands, or the I can't really say though. Could you say the second name with a good accent?
In Cantonese it's Diu Yu Do, but then in Mandarin it's Diao Yu Tai.
Okay, beautiful. I can't say it that nicely. This is a Japanese vessel patrolling, and if you go on, it won't play. There's plenty of, if you search Senkaku Islands dispute, you'd see all of this footage about basically fishing vessels ramming patrol boats and the like. It gets really heated, and then Japan has been setting, military jets over the area, and in recent years. So this was, from a few years ago, possible war over islands was the report on the news. So it gets to that point where they actually might have conflict. But that's really paled into insignificance in the last few years in comparison to China's U-shaped claim. So this is in the South China Sea, and just in the last few years the constructions of artificial islands and reefs. Now it's separate to the Senkaku Islands dispute in the East China Sea. So this basically, China has basically relied upon a map that has literally 9 dots or 9 dashes on it. It's sometimes called the 9-dash line. 1, 2, 3, 4, 5, 6, 7, 8, 9. There's some other versions that have 12, but this is the most common one. Those dashes, basically, it's really weird, the basis of it, but basically it claims sovereign rights to that, basically everything within those 9 dash lines. And a huge amount of shipping passes through that area. Now, if you actually look at just maritime zones under UNCLOS, and you can see the Chinese U-shaped claim if you join all the dots together, like around Brunei and Malaysia, it comes into basically almost touch the shore. It's like quite an amazing claim in many ways. The basis of it around here. So there's the Chinese island here. The Paracel Islands, there was a brief fight between Vietnam and China in 1970s, was it the 1980s, and quite a few Vietnamese sailors were killed, and China basically occupied islands in the Paracel Islands from Vietnam. And then essentially there's a whole range of military outposts there's some islands, but there's also a lot of reefs in this area. And yeah, the Philippines has also got an interesting history in that it was it under Dutch rule, and then the US basically controlled it until World War II. And it's, you know, a relatively new nation. And Vietnam's 200 nautical mile claim comes out here. You've got the Brunei claim here. This is the Malaysian claim, and then Indonesian. So a lot of overlapping claims. Yeah, that's just another representation of the EEZs coming out, and you can see, yeah, the Chinese claim territorial waters. Now, there's really no basis for the Chinese claim other than pretty well assertion of this is ours, but it just looks so weak, other than the fact that, you know, it's like this huge country and very powerful. So it's asserting its dominance in that area. So been a lot of disputes with Chinese fishing vessels going down and fishing in waters of other nations. And yeah, again, if you did a Google search for you know, South China Sea and conflict, you'd see a whole heap of stuff with yeah, reports about the particularly in the last few years, China has upped the ante. In the last few years of the Obama administration, when Obama was very conciliatory, and clearly the US had turned pretty well inward, and Obama was not wanting to engage. You know, they'd just gotten them out of Iraq. He'd just basically pulled them back out of Afghanistan. So they didn't want another armed conflict. And so China clearly took a gamble in the last few years of the Obama administration that the US wouldn't stop them. And what they did was start building artificial islands on top of reefs. So yeah, this is just some of the designs. So here's an example. So this is the Johnson South Reef on Mabini. So, and here's different outposts. So the red dots are Vietnamese outposts, the green dots are Chinese outposts, the purple dots, one from Taiwan, and then the blue one is the Philippines. So, and this is the location in terms of that overall map. And yeah, basically they're turning reefs into artificial islands. This is just a quote from a report at the time. So China's island building is aimed at addressing a serious deficit. Other countries that claim large chunks of the South China Sea, Vietnam, Philippines, Taiwan, Malaysia, all control real islands. But China came very late to this party and missed out on all the good real estate. Beijing only took control of the Johnson South Reef in 1988 after a bloody battle with Vietnam that left 70 Vietnamese sailors dead, and Hanoi has never forgiven Beijing. Since then, China has shied away from direct military confrontation, but now it's decided it's time to move, to assert its claim, and it's backing it up. It's creating new facts from the ground, a string of island bases and an unsinkable aircraft carrier right in the middle of the South China Sea. Manila, so Philippines, knows that there is no hope of standing up to Beijing in a straight fight. So the Philippines has taken its case to the United Nations. It wants a ruling from the UN that basically, yeah, what China's doing around the Philippines is unlawful. Another quote, China is just at the start of its rise as a naval power. The speed of the change is breathtaking. Right now, China is building new naval ships and submarines faster than any other country in the world, including the US. Second aircraft carriers on the way. The US Navy is still much bigger and more powerful, but the gap is closing faster than anyone expected. What's going on in the South China Sea is an expression of Chinese intent. Yeah, and its ambition is to dominate the sea space within the first island chain. In the longer term, it wants to move further beyond the Philippines in what's called the second island chain to Palau, Guam, and the northern Marina Islands. So this is showing that. So the first island chain is that red one, and then long term past Guam. So basically asserting its power in that area. And then, yeah, photos of island buildings. So here's some of the islands. So this is methodical, well-planned campaign to create a chain of air and sea capable fortresses across the centre of the Spratly Islands. So you've got there on the left, March 2014, middle August 2014, and then January 2015 on the right. So dredged channel and a helipad, and basically, yeah, an island in the middle of a reef. Here's another example. This is Fiery Cross Reef. So 22nd of January 2006, and then the same island or the same reef in 2015. Basically, you've got, it's no longer a reef, it's now become an island. And here's, just, you can see the dredges at work. So basically they just went around these reefs with massive dredges and just pumped sand onto them and then reinforced them and built buildings on them. Here's some more of the dredges at work, so massive. And here's yet another example. They constructed the island and then they're building buildings on it. Okay, so what's their legal status? Basically nothing. Article 60, in the EEZ, a coastal state shall have the exclusive right to construct and authorise and regulate the construction, operation and use of artificial islands. And then paragraph 8, artificial islands, installations and structures do not possess the status of islands. They have no territorial sea of their own and their presence does not affect the delimitation of the territorial sea, the EEZ or the continental shelf. Okay, so legally, the countries that are within the EEZ are supposed to control them, but China's just ignoring that. So the legal status of China's artificial islands under UNCLOS, if on the high seas, if they were on the high seas, they could potentially be lawful, but they're not. They're clearly within EEZs of multiple countries. I mean, having said that, you can't have, overlapping EEZs should ultimately be delimited in the midlines. So these countries are claiming overlapping EEZs but refusing to allow refusing to allow them to be split down the middle. So there's a whole range of competing claims. Won't dwell on that. Under UNCLOS, there's a definition of an island. So an island is a naturally formed area of land surrounded by water which is above water at high tide, and rocks that cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. So sounds pretty technical, but basically if it's a rock, you don't get an EEZ. If it's an island, you do, and that's then significant. So the reclamation would technically do little to bolster China's claims to the islands under UNCLOS because these have to be based on naturally occurring features. That said, if China's on the ground and is heavily armed, then it's going to be nigh on impossible for anyone to challenge or remove it, so international law is moot on this one. And that's really the point. Unless the US was to go in and basically bomb them out, so have a war with China, there's no way that these islands are going to be, that China's going to give them up.
So going back, the islands under dispute between Japan, Taiwan and China, they're uninhabited but considered habitable. So they're definitely islands. They're not rocks. No. And they are habitable. They do have water and those sorts of things, but there was some...
But there's no settlements on them?
No. It's not as I understand it. I remember reading an article about some crazy Japanese guy who was all about settling them and claiming them as his own kingdom and that sort, or claiming them for Japan and blah, blah. But as I understand it, there's no actual settlements on them, but they're certainly beyond rocks. A rock, you could basically think of like a something that goes underwater at high tide, for instance. Okay, so the Philippines before the current guy, so Duterte, I always have trouble. This current president, Duterte, he has cozied up to China in recent years and basically walked away from this. But the previous government of the Philippines took China to arbitration under UNCLOS. China refused to basically be a party to it. It said it had no jurisdiction, that it basically refused. So that's why in this image you see on the right there's a blank table because China refused to show up. So the arbitration was held in China's absence, and basically it is this amazing judgment, about 300 pages long, by these really eminent international lawyers, including the guy in the middle. He was an African, the president of it. And these international tribunals, they always try and be completely impartial. And typically, when a panel is formed, there'll be the judges will be from every country except the 2 disputants, and the 2 disputants can each appoint 1 judge. So if you've got like 13, 11 of them will come from countries other than the countries in dispute, and then there'll be 1 each. So they're all from, not from China and not from the Philippines, and the man in the middle, I can't remember which African country he came from. Anyway, it unanimously upheld the Philippines' claim, and yeah, I won't go to the judgment. It's really, really interesting if you're into maritime law, but it basically said that what China was doing in the area near the Philippines was unlawful, and yeah, China has refused to recognise it, and since Duterte was elected, he's really tried to cozy up to China, and one would suspect there's a whole heap of corruption going on there, and you know, China is flooding him with money, but yeah, he's not pushing the Philippines claim anywhere near as much as the previous government did. So that's an example of, you know, an international arbitration, but where one party refuses to even, play ball. Just a couple of things about that. Some interesting. I find this whole area really interesting because apart from the environmental aspects of it, there's, you know, a real chance of armed conflict, and understanding, you know, China is going to be such an important component of our international system going forward. So this article was about China's new weapon for expansion was lawfare. So it was this really interesting report that Professor Stephen Halper did for the US Secretary of Defense in 2013, which was released. And it talked about 3 warfares. So psychological warfare seeks to influence and disrupt an opponent's decision-making capability to create doubts, foment anti-leadership sentiments, etc. Media warfare is a constant ongoing activity aimed at long-term influence of perceptions and attitudes. And then legal warfare exploits the legal system to achieve political or commercial objectives. So, yeah, not just physical armament, but these different forms of, warfare. And I would say, I've made a note there, you know, it's not like China's the only country that uses these. Obviously the US uses this, and Israel as well. Like if you were to go online and criticise, you know, Israel's occupation of Palestinian people, the treatment of them, you could well be bombarded by trolls basically attacking you. Clearly Israel has a very, very strong internet presence, basically pushing back against any criticism of its activities. Psychological and media warfare they certainly engage in, and yeah, legal warfare. So, not saying it's just China, but interesting. Okay, I mentioned the US hasn't ratified UNCLOS, so the US says, you know, these they talk about 200 nautical miles, they say that you shouldn't be occupying these countries, and China's normally response is, but what do you care? You're not even a party to UNCLOS. And so back in 2012, when Hillary Clinton was the Secretary of State, this is a picture of her and the Defense Secretary and the Joint Chiefs Chairman testifying before the Senate Foreign Relations Committee, basically pleading that the Senate approve the US ratifying UNCLOS, because they were saying it is affecting us and our ability to, particularly in the South China Sea. The US, by the way, claims a 200 nautical mile EEZ. They haven't ratified UNCLOS. There's actually no legal basis for it. But if you've got the biggest navy in the world, yeah, no one's going to really dispute your 200 nautical mile EEZ. But it does affect them away from the US coastline. So they haven't ratified it. And so China, I put in brackets there, fairly sees double standards applied to the US when it has ignored international law. And so this is just a quote. Some of the brightest young scholars in China take great delight in reeling off exhaustive examples of American duplicity and double standards. Whatever the merit, second paragraph, whatever the merit of such arguments, one lesson seems to have been taken to heart. Great and powerful countries may not be able to do anything they want, but they can do a lot more than weak ones, and it is precisely because China has become so much more materially consequential, both militarily and economically, that its leaders clearly feel they can take more calculated risks, and building the artificial islands to bolster its territorial ambitions in the South China Sea is clearly a calculated risk. And at the moment, it's paying off really well for them, because essentially they've built them, haven't been stopped, and they've got now these impregnable fortresses. I mean, impregnable, modern age. They could be blown out of the water, but you know, it would be provoking war between two superpowers, so the US isn't going to do that. So that's maritime zones. Fascinating topic, isn't it? So only thing that I really want you to understand for the purposes of our course is the 200 nautical mile EEZ and, you know, continental shelf, and basically our rights. You know, countries can control within the 200 nautical mile EEZ, and also out the continental shelf you can control oil and gas exploration. Beyond that, all the other things, everything else is really just detail. Cool. Do you want to take a break? Go into marine pollution? How long have we been going for? We've been going for an hour. Why don't we pause, stand up, walk around, we'll go into marine pollution. Does anyone feel hungry and want to go and get a pizza or something?
No.
Okay, we've probably got an hour of marine pollution. So we can take a break and go and get a pizza. I should really shout, since we're here late because of me.
I couldn't stay home now, so I'd rather just
Okay.
go switch it, but that's selfish.
Hey, so before we took a break, we were looking at UNCLOS and maritime zones. As I've said, fascinating topic. I hope I don't seem too at the top with it, but yeah, it's just so important. So important in so many ways for, you know, fisheries, petroleum rights, and also the sustainability of, you know, the uses of those areas. So really, really valuable and important topic. Okay, let's move on to marine pollution under UNCLOS, or regulation of marine pollution, especially from land-sourced sources. So we looked at MARPOL, and often people distinguish between ship-sourced marine pollution and land-sourced marine pollution. So obviously, you know, if you've got a big oil tanker, that's a source, but land-sourced marine pollution can be things like sewage, you know, anything that's coming from the land. So I'm going to look at a couple of examples, the Mississippi River and the Rhine River in Germany. So here's a map of dead zones. So these are areas where basically there's so much nutrients, they've basically caused massive algal blooms. When the algae sinks down to the bottom, it causes you know, bacteria break it down, use up all the oxygen, and essentially you end up these areas where the water is completely devoid of oxygen and everything dies. So yeah, linked to nutrients particularly. So east coast of the US, Europe, and also China. So yeah, the basic idea is, as I've just described it, so you get nutrients coming in from typically coastal agricultural you know, runoff, so big farm areas, a lot of nitrogen and phosphorus getting into the water, and that then allows, so nitrogen and phosphorus are the basic things that algae need to grow, and you add in lots of that, you get a lot of algae, and then that dies, and when it dies and sinks down to the bottom, yeah, you can end up with areas where the oxygen all gets used up by the bacteria breaking it down, and then that oxygen, if it then, the water that's got no oxygen in it, if it basically rises up to the surface, you pretty well kill everything. So here's just an example. Here's another diagram showing dead zones. So you've got in the left fresh water coming in with nutrients in it, and then you get an algal bloom in the middle and dead algae floating down, and then oxygen deprived salt water, you've got a dead zone and it can basically reach the surface and everything dies. So here's quite a graphic example of, you know, the split between different water. So the dead zone the size of the state of New Jersey lies in the Gulf of Mexico near the mouth of the Mississippi River. Here, water from the Mississippi laden with sediments, organic material, nutrients and pesticides enters the Gulf of Mexico. And yeah, routine fish kills, low oxygen water. You might think, you know, a few fish, no big deal. It's the scale of these things that is really the issue. So the Mississippi River flows down to New Orleans, and yeah, it's a massive, massive river system. And within it is a huge amount of agricultural areas. So bringing nitrogen, phosphorus down to the river. This is a satellite image showing the reds and oranges represent high concentrations of phytoplankton and river sediment. And this is winter. So summer, winter, and then here's another image around the similar area showing dissolved oxygen, and the red basically being areas where there's no oxygen left in the water. And then, yeah, bottom dissolved oxygen in 2011, and again, just the red being no oxygen at all across large areas. And yeah, just again, red being no oxygen. So where's the nutrients coming from? They're coming from a whole range of crops. So the green is corn and soybean crops, yellow is other crops, the light brown is pasture and range, the blue is urban and population related sources, and yeah, the red is from the atmosphere, and then grey is natural land. So a whole range of sources across a massive area, very, very difficult to regulate. And of course in the US and in that area it'd be across many, many, many states. So you've got to work together, and each individual, like if you're a state that is inland and you're not actually, you know, like at the Gulf, then, you know, your imperative might be to produce a lot of crops, and you don't particularly care about what happens downstream, because that's not your problem. So difficult to get everyone to work together. Here's just a diagram showing, you know, different sources, cropping, etc., sewage, all of this going into the river, nitrogen fertilizer being applied to a field of corn. So what does UNCLOS say about that? Obviously the US isn't a party to UNCLOS, but or hasn't ratified it, so it's not bound by it, but just in that sort of context, UNCLOS places a general obligation in Part 7, Article 192 to protect and preserve the marine environment. Article 194 imposes an obligation to prevent, reduce and control pollution of the marine environment. And yeah, goes on, measures shall include from all sources, pollution from vessels, etc. And Article 207, pollution from land-based sources. So states shall adopt laws and regulations to prevent, reduce and control the pollution of the marine environment from land-based sources, including rivers, estuaries, pipelines, etc. So those are your basic obligations: prevent land-sourced marine pollution, land-based sources. Article 208, pollution from seabed activities subject to national jurisdiction. So the Deepwater Horizon is the sort of thing that could be regulated, you know, drilling on the seabed, the potential to cause pollution. Article 208 says you've got to regulate that. So pollution by dumping, prohibition on allowing dumping into the marine environment. 211, pollution from vessels. So obviously there's an overlap here with MARPOL, but UNCLOS is basically trying to be comprehensive. So it obviously knew that MARPOL existed. It was trying to create, though, a holistic system. But yeah, obvious overlap. And MARPOL tends to be much more detailed than the UNCLOS measures. Okay, so that's the Mississippi River. A positive story is the Rhine River. So, you know, the Rhine, massive river in Europe, flows from Switzerland, France and Germany. Perhaps mostly associated, I would mostly associate it with Germany, but that might just be my limited geography. So you can see where it's winding from. Huge industrialisation across its catchment. So here's a power plant in the 1940s, and yeah, a lot of development along it, obviously. So one of the seminal, though, events in the history of the management of the Rhine was a fire at Koblenz. So here's an industrial area in Koblenz, and yeah, this Sandos disaster in, was it Koblenz? Sandos disaster in Switzerland involved a storehouse for pesticides, solvents and dyes, and basically it caught fire. And so the huge fire, the fire brigade came and hosed a whole heap of material on it. It all went into the stormwater drain, and the chemicals from the factory were washed down the river and caused this massive fish kill from the Sandos disaster. So this is just some pictures of it. So 1986, and yeah, led to huge die-off in the river. And 1987, there was the Rhine Action Program. So in response to this disaster, so disaster-driven, sometimes known as Salmon 2000, it became, because its stated target was to see the return of salmon to the Rhine by the year 2000, and salmon, known for their sensitivity to water pollution, returned to the Rhine in 1997, 3 years ahead of schedule. So basically, it was a big program to clean it up, and I think at the moment they've got a Rhine 2020 program aims to make the Rhine clean enough to swim in by 2020. So massive effort to keep it clean. Just wanted to touch on UNCLOS marine pollution. It covers land source marine pollution. So it's directed at the ocean, but can cover terrestrial activities. Okay, so a couple of other things about UNCLOS. Deep sea mining outside of EEZs is controlled under UNCLOS Part 11. It's regulated by the International Seabed Authority, and apparently this is one of the reasons why the US Senate is so against the UNCLOS, this International Seabed Authority. I don't understand why, but I've seen news reports saying that this is one of the big things. So just to mention, I've said the area is this term that's used confusingly in UNCLOS. So area is defined in Article 1 to mean the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. Who can think of a better term than the area? Surely, you know, seabed. Why don't we just call it the ocean floor? Why couldn't it have been called the ocean area? It could have been called, surely the ocean floor would have been a better term than the bloody area. Because what does it mean? Because you get now, like if you look at the Part 11, it just talks about the area. The area and its resources are the common heritage of mankind. Well, but in the article, you don't actually understand what the area bloody is. 137, basically, no state shall claim or exercise sovereignty or sovereign rights over any part of the area or its resources. So basically, now, the thing with deep sea mining is it hasn't been really viable until recently. But in the last decade or so, there's been a lot of advances in robotics and the ability to send things really deep. And there's been a focus on hydrothermal vents because, where the hot water is coming out, hot vents, you can have accumulations of particularly metals like gold and the like in really high concentrations. So it can be really valuable to go and mine even small amounts of them. So you can see here some of the vents shown, known hydrothermal systems and polymetallic massive sulfide deposits. So here's a smoker or a hydrothermal vent, and just a diagram showing it, what's happening, heat rising up, you get concentrations of metals. So an example of seabed mining, it isn't actually on the high seas, or it isn't in the area. It's an area in PNG. So obviously with those islands wrapping around, that's all would be PNG coastal waters, rather than the area, but it's very deep. And those are petroleum tenures that have been granted over that region. And here's just some images from this project. And one of their platforms going down, really deep, mining essentially these vents. So it's an emerging area because of advances in the ability to mine these places. And they can have really high concentrations of gold in particular and other metals. So that's why they're being targeted. Cool. Okay, so that's deep sea mining. I only wanted to touch on it because it's an emerging area. Fisheries management under UNCLOS. So within under UNCLOS, within the EEZ, fisheries management is very strong. On the high seas beyond the EEZ, UNCLOS is weak. That's the basic split. So you all know about the decline of fish stocks. I like these images. I thought brought home to me the idea of decline. So this is an example of trophy fish caught at Key West. The top one is 1957, and you notice some really big fish. And then B is the early 1980s, and you notice they're getting a bit smaller. And then 2007, the winners of this fishing competition. Notice a big difference from the top to the bottom. Someone mentioned to me that in that area, groper are now protected. So some of the fish in the top are actually groper. So there might still be big groper there, but you're not allowed to catch them. But still the point is, you look at what won that competition, a big decline in the size. So 1957, 1980s, 2007 seems pretty pitiful, really. Okay, a famous example of fisheries collapse is the Atlantic cod, so found in northern Atlantic. Here's the collapse. So from the 1950s, onshore bottom trawlers began exploiting the deeper part of the Atlantic cod stock, leading to a large catch increase and a strong decline in the underlying biomass. Internationally agreed quotas in the early 1970s, and following the declaration by Canada of a near exclusive fishing zone in 1977, national quota systems ultimately failed to arrest and reverse the decline. So you get here this rise in catch, peaking in about 1968, and then within 10 years having collapsed from 800,000 tonnes to 150,000 tonnes, and then it continues for another decade, and then complete collapse by 1992, basically catching nothing. And then there's a little bit of a catch you see there around 2000. So the classic example of fisheries collapse. So fisheries management in the EEZ under UNCLOS, you've got the EEZ, the coastal state can determine the take, so that's strong. Article 61, use the best scientific evidence and the like. Article 62, utilisation of living resources. Optimum utilisation is the concept. And nationals of other states fishing in the EEZ shall comply with the conservation measures of the laws of the coastal state, including licensing, determining which species can be caught, regulating seasons and the like, fixing the age and size of the fish. So really detailed is what I'd emphasised. Enforcement and laws of regulations of the coastal state. So basically, the coastal state can enforce its laws. Just as an example of the difficulties, though, in particularly remote areas, back in 2002, Australia was notified by the Australian Fisheries Service was notified by an Australian vessel of some Russian vessels illegally fishing around Heard Island, which is, and I make the point here, you've got to enforce these laws if you're going to be effective. So Australia sent down the HMS Canberra And Heard Island is located about 4,000 kilometres southwest of Perth, so it's really remote. It's one of Australia's sub-Antarctic islands. And basically the Canberra arrested, there were two ships, Russian flag ships that were fishing, the Lena and the Volga. The Canberra arrested the Lena and it pretty clearly radioed the Volga. The Volga was hightailing it for the high seas, so out of the EEZ, the Canberra sent a helicopter to engage with the Volga. It reached it when it was, I think it was 0.6 of a nautical mile outside the EEZ. And under the UNCLOS, there is this concept, it sounds like it's from the Dukes of Hazzard or something, but it's called hot pursuit. And you can't just arrest a vessel on the high seas, but if you commence pursuit of it within your EEZ and it flees outside, you can still arrest it. So, but you have to commence hot pursuit, and it has to be done by a visual signal or a audible signal. You can't just do it on a radar. You can't like commence pursuit on a radar and then you catch up to them. So yeah, hot pursuit. So they hadn't commenced hot pursuit within the EEZ, but they proceeded to arrest the Volga anyway. So here's the location, and you can see here the split. Why do you reckon there's that split for the Kerguelen Island? Based on what we've already talked about.
It belongs to other countries?
Who do you reckon it belongs to?
New Zealand?
Not quite, other side of Australia. I'll give you a hint. In the middle of Australia's Antarctic territory, there is a little sliver belonging to a European country that was doing a lot of exploring at the same time as Captain Cook.
It's in France.
France, yeah. So it's French territory, and that's why there's a split. So very remote, covered in snow and ice. You might think it looks a lot like Antarctica. Why can we have sovereignty over those islands but not Antarctica? I'd ask you the same. Because no one lives on it, by the way. So it's not like, what's the difference? The difference is only political. So there's an old weather station on Heard Island. Okay, here's some footage. I just want to show you. Here's a helicopter landing, and this is them arresting it. I just want to play you the footage of it. So this was given to me by the Australian Navy. I asked them for it, and they were kind enough to give it to us. So yeah, it's a bit shaky to start with. So this is from, the footage starts with the, this is from the helicopter when it's caught up to the Volga. It's just made it into the high seas, and they're basically circling it, but they don't board it. Basically, they waited until the Canberra caught up, so that they're basically circling it, and then basically the Canberra caught up, and the helicopter went back, and here's them about to launch. Here's the boarding party getting ready to go. Here's them getting on the helicopter. And then they fly out. And so you can see the Canberra, this footage taken from the Canberra, and now they descend down. So it's called fast roping. They drop a rope out, and they just basically have gloves on and a thick rope, and you slide down the rope. I think it's funny, here comes the guy, and you might think, hey, there's a problem! There's not a boat. And then, do you think you stop there? Do you think he's saying, over there, you bloody idiot! Go over there, go there! I don't want to go in the water! And he's down. And anyway, they land all these people on it. And then there's another boarding party going across on the boat. He doesn't look very keen, that guy. This is after they... So this is now footage of the investigation. The guys in blue are the fisheries officers who were with the Navy. And basically the guys in green are the naval guys, and they're now inspecting the ship. What came out in the later court cases about it was the crew produced a logbook. So these are Patagonian toothfish, that's what they're after. And basically, the judge described how the evidence from these guys, they went down and the decks were... So the Russians produced a logbook to say that they were just... there was innocent passage, they weren't fishing within the Australian waters. They had been fishing everywhere else except Australian waters. But the evidence from these guys was when they went down onto the fishing decks, the decks were wet. When there were fish that were still on the line, when they picked them up, blood came out of their gills, so they're obviously very freshly caught. And the crew managed to hack the navigational system for the ship, and it showed that basically it had been fishing completely within the Australian EEZ. So all of that was used as evidence of basically illegal fishing. And then what Australia tried to do was basically would refuse to release the ship until a bond was paid, but also they wanted a vessel monitoring system attached to it. And that's not something that's kosher under the UNCLOS system. So Russia brought an application in the International Tribunal for the Law of the Sea for prompt release of the vessel. Exciting example of, and also the difficulties of enforcing, fisheries regulations in remote areas. It's expensive, it's hard. Just some images of the fisheries guys. So expensive operation, difficult. Here's the crew. So there was a couple of court cases out of that. One in the Federal Court of Australia and one in the International Tribunal of the Law of the Sea. And you can read about them if you want on my website. So yeah, I was really interested in those cases at the time and just, the enforcement of fisheries laws. And I contacted the Navy actually because I'd seen some still images and I asked if they could have any photographs. And it just happened to be that the guy in charge of the Freedom of Information section of the Navy happened to be the officer who was also in charge of, I think it was the public relations or some aspect of this operation. So he sent me this CD with the video footage and all these pictures. It was really cool, and all of these documents, they were really, really helpful. Okay, so UNCLOS is a tribunal established under the United Nations Convention on the Law of the Sea. Here's a picture of it. Again, international tribunals, lots of judges, and then people appearing before them. The Volga case, the judgment basically was against Australia, saying what Australia had required was not kosher. Just emphasise the point, UNCLOS gives you a lot of powers for coastal states. Outside that, it's pretty weak. So the high seas provisions, so the EEZ was really detailed. The high seas, there's basically nothing there. You go and look at the high seas provisions, it just says pretty well nothing. So freedom of the high seas is the emphasis. Freedom of navigation, freedom of everything. Conservation and management of living resources. It emphasises really the right to fish. All states have the right for their nationals to engage in fishing on the high seas subject to their treaty obligations. And then Article 117, all states have a duty to take or to cooperate with other states in taking such measures for their respective nationals as may be necessary for the conservation of living resources of the high seas. But it's really, really weak. So there have been ongoing movements to improve high seas management under UNCLOS, but it hasn't yet resulted in, it's an area where we could see UNCLOS being advanced in the future, but at the moment, you basically have to look at other treaties. So I just want to wrap up this lecture, maybe 15 minutes, on a couple of other treaties. So tuna is the first one. Is that okay? So southern bluefin tuna. So this is an example, and as I say, the reason why you have to consider these other treaties is because UNCLOS is so weak on the high seas. So for fish that go onto the high seas, like tuna, and you've got like a lot of, and it's a valuable resource, the countries that fish it have a real interest in managing it sustainably. So southern bluefin tuna, obviously very highly prized in Japan for eating. Not so much, I would think. You know, Japan is really the global market for it. Here's, you know, amazing fish. The southern bluefin tuna, here's their distribution across, obviously, the Southern Ocean. Their spawning grounds are between Western Australia and Indonesia. You see them up there. And then the young move away from the spawning grounds in south and then into this Great Australian Bight. So an older southern bluefin tuna move in and out of the Australian fishing zone in those areas. So obviously Australia can't manage the stock itself. And yeah, they're massive. Now notice behind there's those nets. So a common practice in recent years has been to go out, encircle an entire sort of small group of, you know, a school of tuna in a big net, and then drag the net back into coastal waters and then feed the fish for however long until they grow big, and then you just harvest them. So that's what the nets are. They do have a problem with, you hear reports of great whites leaping into the nets, which would be, yeah, pretty interesting. How do you get it out? Over here, fishy. I know a shark isn't a fish, but well, not a bony fish. What are they? I can't remember. I should remember my basic biology. Anyway, here's some frozen bluefin tuna, all at market. Here is an example from. It's quite. There's a tradition around, you know, bidding for the first fish of the season. So here's a sushi restaurant paid a record 1.7 million Australian for a 222 kilogram bluefin tuna at the first sale in 2013. So, and, you know, big advertising thing, you know, for the restaurant. So incredibly valuable, $1.7 million for one fish. What's happened to southern bluefin tuna is shown in this graph quite well. So you've got 1960, the stock basically, so this is, you know, when you get industrial scale fisheries, big ships or big vessels with modern fishing gear going after them, in a, you know, en masse, and you get this massive decline down to now where they're about 10% of the original biomass. And here's the take through that time. So in the 60s, you see it just massively spikes, mostly Japan and then Australia coming in as well, but mostly Japan. And that's just some different maps of different takes and different times of year. So the catch spreads around depending on where the fish are. And yeah, lots of the convention on the southern bluefin tuna meet each year, and there's often news around it with it being controversial or what's happening with them, because they're very valuable in Japan and Australia. The fisheries are very valuable. So the Convention for the Conservation of Southern Bluefin Tuna, created in the 90s, Article 3 says its objective is to ensure through appropriate management the conservation and optimum utilisation of the southern bluefin tuna. Article 6, the parties hereby establish and agree to maintain the Commission for the Conservation of Southern Bluefin Tuna, hereinafter referred to as the Commission. Article 7, each party shall have one vote in the Commission. Decisions of the Commission shall be taken by a unanimous vote of the parties present at the meetings. So here you're establishing machinery, unanimous vote, everyone gets one vote. Article 8, for the conservation management optimal use of the southern bluefin tuna, the Commission shall decide the total allowable catch. And yeah, you can go onto their website, and yeah, basically they have a scientific committee that advises them on what's sustainable, And you can see here from the 1940s with the spawning biomass, this massive decline through the 60s, down to where it's basically around about 10% of the original biomass. And then they've been modelling, this is from the scientific committee, modelling based on different catches. So if you set a catch limit at 0, so this was in 2009, okay, so basically they're modelling at this point. So from 2009, what will happen if you basically said 0 catch? Well, their models project that the species would recover, so that by 2030 it would be about 5 times the size that it is now in terms of total biomass. The opposite of that is if you have the catch at 15,810 metric tons, so that's what the MT stands for, basically 15,810 tons, that basically the population would crash and be pretty well wiped out by 2022 or thereabouts. And in between that, you've got the different lines. So what do they then, this is what the scientific committee is saying to them, and they then use that as the basis for allocating catches. Now, they couldn't bring themselves to say 0 because it's so valuable. And basically in 2009, this is just an example, obviously historic, but just shows you the sort of, so based on their scientific advice, the total that they agreed on was 9,354. So basically the green, see the green? It's pretty well in the middle. It's just allowing it to increase, but not very much, not very fast, but not getting worse either. So that's the most that they could agree on. And you could say, well, that's the optimum utilisation, You're actually still using it. You're not just saying no catch. And you're also not basically allowing catch limits that basically force the species to crash. So, there's a heap of information available on the website. An example of science being used for fisheries management and allocation of southern bluefin tuna catch in 2014. You can see there Japan, Australia, Korea, but Japan and Australia being the big ones. And there's similar issues for other tuna fisheries. So there's the Pacific tuna industry, the big eye stock collapse. This is just a report from 2014. Pacific tuna industry has joined the environmental organisation scientists calling for a serious action to save big eye tuna. More than 60% of the world's tuna is caught in the Pacific, much of it by powerful distant fishing nations from Asia, Europe and North America. Basically saying they're pretty well being wiped out. This was a really interesting report a few years ago about Palau, which is a small island nation east of Japan, the Philippines. Beautiful little island nation. And this report was on ABC Foreign Correspondent about the difficulties, because Palau, this was the president of Palau saying, Palau is so fragile and so beautiful, you just have to take the responsible action and minimise the risk that would destroy all of this for our future, for our children and future children. And basically Australia has given to Palau a patrol vessel. It's the only patrol vessel it's got. It's got an Australian captain, but crewed by Palau nationals. Really interesting documentary. And basically what the documentary said was they've only got one vessel. It's obvious when it's going out, and people just, the fisher people have just got, watches in port when it goes out. They just get on phone and say, hey, the patrol vessel's heading out. And these vessels that come in, they sort of come in really quickly into the Palau EZ fish and can scoot back out. So enforcing Palau's fisheries controls is really difficult. And yeah, in practice, they're just being beaten by technology. So fishing vessels coming in high, using modern sonar, modern equipment, really fast, really powerful, and these fisheries stocks are still being devastated. So yeah, there's the Convention for the Conservation and Management of Highly Migratory Fish Stocks in the Western and Central Pacific Ocean, 2000. Just another example of a fisheries convention. Covers that area. And participation convention members, including Palau and Australia. And yeah, close relationship between UNCLOS and that convention. So basically it mirrors the UNCLOS and basically tries to set up a high seas fisheries regime for the Western Pacific. So yeah, it's late, won't probably discuss this, I'm sure everyone's tired. The difficulties of managing fisheries both inside and outside, neither of them are easy. It's remote, even inshore areas, it's not like you can just walk up and, it's difficult. There are people that are at sea, fishing vessels are, can be difficult to monitor. There's modern equipment. And then when you go into the high seas, it's even harder and it's expensive. Remote areas, a lot of money to be made from, fishing in protected areas or areas that, a country is controlling well. So really difficult, really hard to see how we're going to do better in the future as well. I'll put the link up to this. It's a really powerful documentary showing a lot of issues for a small island state. Okay, so just wrapping up, now it's late. Talked about UNCLOS. Maritime jurisdictions is a big thing because it's the springboard to access to resources and controlling fisheries. We've also talked about a few high seas fisheries regimes as well. There's plenty of others, like plenty of other fisheries ones. Just use them as examples. So in summary, and I think this is the second last slide, in summary, international law of the sea has evolved significantly over the past century and it's important to understand its background. UNCLOS is a very important framework establishing national jurisdiction over adjacent maritime zones, but there are important ongoing disputes in some areas linked to control of resources such as the Senkaku Islands. Third, coastal states can control fisheries and resource extraction within their EEZs, and this is a particularly important zone. Fourth, enforcement of fisheries laws remains difficult, particularly in remote areas. And fifth, management of fisheries outside of national waters on the high seas remains very difficult, and there are many international conventions dealing with specific fisheries, such as the Southern Bluefin Tuna Convention. Okay, I'll put up, I actually think the link might be there. It's well worth reading if you're interested in small island states and fisheries. There is a whole chapter in the training manual. I don't really think, there's plenty of information on. If you wanted to look at anything, I would go to the UNCLOS website. The Southern Bluefin Tuna one is really interesting as well. And that's it. Thanks guys, thanks for patience. Sorry we didn't start too late, so we finished so late tonight. Really appreciate that you hung around. Okay, so let's call it at that, hey? I will put up a lecture about how not to do research, but let's not do it now.
Just one question. I'm
Yep.
a bit confused for the slide that you mentioned where they have a net and then to take the bluefin tuna back to EEZ so they can fish them.
Yes.
So why do they need to do that when there is not really law for fishing in high seas?
They don't necessarily catch them on the high seas. It's just that they basically do that because, it's basically just bulking them up so that they're more valuable. So if you put a big net around them, and it might be done within an EEZ, it would still be within the total allowable catch. I don't know how they work out then tonnage. Like if you're allowed to, if you're a fishing person,
they were little when I caught them,
and you're allowed to, harvest, 10 tons, and when you get them they're 10 tonnes, but then you grow them to they're 100 tonnes. I don't know how that works, but that's quite common practice. I'm not a specialist in southern bluefin tuna, but yeah, they net them and then bring them in to protected areas, not protected areas, protected waters, and yeah, feed them up and harvest them when they're at their optimum size. So
how can Japan do that? Because these fishes are like active in the southern side.
I don't know. I don't know. The person there looks like he could be Japanese, but I don't know whether. I know that in the south of Australia, in areas they do this because one of the complaints is they've put so much feed in it that it causes water pollution around them. So there's concern in some of the bays where this is done that it actually causes water pollution. But I haven't, examined it. It might be particularly aimed at Australian conditions because Australia gets them when they're quite small. So if you can get them as juveniles, but you've caught them and then you grow them bigger, whereas if you catch them on the high seas when they're already big, well, there's no point trying to grow them bigger. So I don't know more than just the general outline of them doing this. So sorry, I can't answer fully. Okay, any other questions? No, thanks guys.